Welcome to our channel Future Stenographers. Ready for the dictation. 10 seconds, 5 seconds. Ready, start. An affidavit purported to have been signed by the appellant was filed with the bank to make him the second guarantor. Stop. Appellant had never signed the document and his signature was forged. Stop. A writ petition was filed before the Allahabad High Court to quash the notice issued by the bank. Stop. The writ petition was dismissed, giving liberty to the appellant to seek appropriate remedy. Stop. On 13 July 1998, an application was filed before learned CJM alleging commission of offences by the named accused persons. Stop. Learned CJM directed the police to register and investigate the case. Stop. As noted above, on the basis of order of learned CJM, the FIR was registered. Stop. The essence of the grievance of the appellant was that the accused persons, with the help of the bank manager, made forged signature of the appellant in the agreement form and an affidavit to show him as a guarantor. Stop. After investigation, charge sheet was filed by the police on 13 September 1999. Stop. On 24th May 2000, respondent number 1 filed the application under section 482 of the code for quashing the FIR, the charge sheet and the order of learned magistrate by which he had taken cognizance and the order directing the police to register the case under section 156 of the code. Stop. By the impugned order, the High Court quashed the charge sheet on the ground that the magistrate had no power to order registration of the case. Stop. In support of the appeal, learned counsel for the appellant submitted that the order of the High Court is clearly contrary to law and on misreading of the provisions contained in section 156 of the code. Stop. Learned counsel for the respondent number 1, on the other hand, submitted that the true scope and ambit of section 15 of the code has been kept in view by the High Court and the impugned order does not suffer from any infirmity. Stop. Learned counsel for the state supported the stand of the appellant. Stop. In order to appreciate rival submissions, section 156 of the code needs to be quoted. The same reads as follows. Next para, inverted comma start. Police officers power to investigate cognizable cases bracket 1. Any officer in charge of a police station may, without the order of a magistrate, investigate any cognizable case which a court having jurisdiction over the local area within the limits of such a station would have power to inquire into or try under the provisions of chapter 13. Stop. Bracket 2. No proceeding of a police officer in any such case shall at any stage be called in question on the ground that the case was one which such officer was not empowered under this section to investigate. Stop. Bracket 3. Any magistrate empowered under section 190 may order such an investigation as above mentioned, inverted comma closed, full stop. Next para, section 156 falling within chapter 12 deals with powers of police officers to investigate cognizable offences. Stop. Investigation envisaged in Section 202 contained in Chapter 15 is different from the investigation contemplated under Section 156 of the Code. Stop. Chapter 12 of the Code contains provisions relating to inverted comma start information to the police and their powers to investigate inverted comma closed, whereas chapter 15, which contains section 202, deals with provisions relating to the steps which a magistrate has to adopt while and after taking cognizance of any offense on a complaint. Stop. Provisions of the above two chapters deal with two different facets altogether, though there could be a common factor: complaint filed by a person. Stop. Section 156, falling within Chapter 12, deals with powers of the police officers to investigate cognizable offences. Full stop.